Hey, welcome back, AP Government. Hopefully you're doing well. This video should be the last video when we look at the judicial branch. What I want you to do is you're going to have an assignment on video number 40 and then video number 42. 41 is going to be the one that I did going over the different required court cases. So there'll be a different assignment on that one. So kind of mix it up a little bit. But this video is going to go through how the Supreme Court operates, a little bit more about the Supreme Court, some key things I want you to know. And then we'll get into judicial activism versus judicial restraint, and then a little bit on how Supreme Court judges are appointed and confirmed. So a lot to cover in this video, so buckle up. Here we go. A couple facts about the Supreme Court. If you remember, this is the only one actually mentioned in the Constitution. All other courts were created by Congress. The number of justices are set by Congress. As we kind of know, maybe there's the discussion about court packing or whatnot could take place with Biden's administration coming on. It's probably not going to happen. I don't think there's enough support on the Democrat side and Republican side to make that happen. But judges, their salaries, the court structure, that's all set by Congress outside of the Supreme Court. Supreme Court's the only one mentioned in the Constitution that you have. There's only two types of original jurisdiction in the Supreme Court. So original jurisdiction means that the court case actually originates. It starts there. Okay. And this is going to essentially be if we're having like a foreign ambassador, someone involving, like France and another country, that would originate there. Also, somebody involved in the executive branch itself, U.S. versus Nixon, Marbury versus Madison are classic examples of that other original jurisdiction, someone actually within the federal government themselves. That would not go to like a district court and then a court of appeals. That would just go straight to the Supreme Court. And then the 12th Amendment, the 11th Amendment is the one that says the suits between states. So if like Virginia wanted to sue Maryland or something, that would now originate at the Supreme Court. They meet on the first Monday in October until June. That's usually when they release all of their overall, reports and whatnot. They definitely hear fewer than 2% of appeals. I really want you to know this term. We're going to address it quite a bit. They have a very narrow, limited jurisdiction. And they're going to issue something called the writ of certiorari. And it's a big word. Writ of, this is not looking good. Cert. We're just going to abbreviate it. Writ of cert. This is kind of like you ever seen the movie Willy Wonka and the Chocolate Factory. This is your golden ticket to get the Supreme Court. If they issue the writ of cert, it means they want to hear the case and they're going to bring it forward. Okay. Again, just a little bit of facts here. The salary is not amazing, to be honest with you. You can make a lot more money working in the private sector than you can, in the public sector. Of course, you work this job until you die, right? There's no, you can't get fired unless you commit a felon or a crime or whatnot. But largely, these positions are extremely powerful. So you are serving the country by serving as a Supreme Court justice, as opposed to working as a lawyer or even a judge elsewhere. But you do serve for good behavior, though you may retire at 70 with full pay. Okay. There are 9 justices on the Supreme Court. There's 1 chief and 8 associate. But don't think of the chief as being the head honcho. If Roberts was to step down, Biden could appoint the next chief. It doesn't have to be like a seniority thing. So you're just the one who kind of calls order. You're the one who kind of calls the discussions going on. But there are 8 associate justices. So here we go. You can definitely see that it is a pretty strong conservative balance right now. Justice Roberts, John Roberts, he's kind of a conservative, not always though. He's definitely one of those ones that can make it a 5-4 or 6-3. Clarence Thomas is probably a C++, very, very conservative. Amy Coney Barrett, she's the latest justice that was confirmed very, very recently. I probably would give her a C+ as well. She's pretty conservative. Elena Kagan is a liberal justice. Brett Kavanaugh is conservative. Neil Gorsuch is conservative. Stephen Breyer is probably one of the more liberal justices. Kind of give him an L+. Samuel Alito is conservative. You don't hear a whole lot about Alito. He was appointed during George W. Sonia Sotomayor is another liberal justice. But again, on balance, you got a 6-3 balance overall. By the way, if it's a 4-4 decision, let's say that there wasn't a fifth justice, or if there's ever a tie, the lower court's decision would stand. And so that's always kind of talked about to make sure you always have an odd number of justices so you don't have that. But this, by the way, is your legacy as the president, because you might serve 8 years if you're lucky as president, but you get to appoint justices on the Supreme Court that can serve 30, 40, 50 years. I mean, look at Obama. Obama appointed Sonia Sotomayor and Elena Kagan, and they were both in their 40s when they were confirmed. So they can be on the court now for decades. Same kind of thing with Trump. Trump has appointed one, two, and now three justices on the Supreme Court. And these justices are all relatively young. I mean, 50s, some of them more in their 40s, but they could be on the court for decades and decades and decades. And that's your legacy as a president sometimes, is to appoint judges. Okay, here we go. Here's just a picture of them. There's John Roberts, the Chief Justice. There's Clarence Thomas. He's the second African-American to serve on the Supreme Court, right behind Thurgood Marshall. There's Stephen Breyer. Samuel Alito. I'm going to go through some of these pretty fast. You don't need to know too much about them, but there's Sonia Sotomayor. There's Elena Kagan. There's Neil Gorsuch. He was the one that they actually got rid of the filibuster for Supreme Court nominees to get him through. I believe it was like 2018 is what I want to say, is when his confirmation was. There's Kavanaugh. Kavanaugh was a very contentious confirmation hearing. All sorts of accusations about his private life came up. But he was confirmed ultimately with a 50-48 vote there. And then here's Amy Coney Barrett, and she clerked for Antonin Scalia. Okay, the clerk will hear a case if it's got broad public significance and it may raise a constitutional issue. Now, understand, they have an incredible amount of ability to determine their caseload, right? Like, there's very few cases that have original jurisdiction at the Supreme Court. So they have appellate jurisdiction. So that means they can hear any case they want to, and they can basically say, we want to bring that case forward. So if it's got a broad public significance, something that the country is really kind of dealing with, you think of like a Obergefell versus Hodges, right? The gay marriage Supreme Court case, or if it's a constitutional issue and it needs to be addressed because Congress hasn't stepped up to pass anything. So now we have to kind of step in, and the courts get to kind of be like the referees to say, well, this is where they feel like the Constitution is leaning. They will do that. Okay, again, you have definitely original and appellate jurisdiction. The original jurisdiction is very rare. Probably like, 0.01% of the cases are coming through their original jurisdiction, maybe some with like foreign countries outside of America. But for the most part, again, it's appellate jurisdiction. They have the final authority. Okay. Here's how the Supreme Court operates. You need to know this term, the writ of cert. This is going to be given by the rule of 4. Essentially, 4 Supreme Court justices have to agree to hear a case. So when they want to bring a case forward, they're all sitting around a big table, and they say, who wants to hear it? If 4 judges raise their hand and say, I want to hear that case, bring it forward, that's called the rule of 4, and that is brought to the Supreme Court. It does not take a majority to bring a court case to the Supreme Court. Just takes 4 judges to say, we want to hear it and we want to bring it to the Supreme Court, which is interesting because obviously you got the whole issue going on right now. Trump is still challenging the election of 2020. Are there enough conservative justices to try to bring that issue up at the Supreme Court? Because it only takes 4 of them. I don't know if Roberts would be on board with that one, but we'll see how that kind of plays out. If, the other justices can get on board, if they want to support that or not. It just takes 4 if they want to bring it forward to the Supreme Court. So stay tuned on that one. Okay, the procedure for the Supreme Court is something I like to call BOCO. This is Mr. Matthews' kind of way to describe it. Nothing AP word, but we'll explain BOCO here in just a second. Influence on Supreme Court's opinions. Stare decisis is the biggest influence on the Supreme Court. Stare decisis is precedent. What have we done in the past? Let's let that guide us on what we do in the present. Whether it's, whether or not we want to give free speech to corporations and advertisements when we go to Citizens United versus FEC. Whether it's, we want to say that the Supreme Court is obviously allowed to overturn laws, right? Judicial review, right? That's obviously a landmark decision. That one's not ever changing. Integration of public schools, Brown versus Board of Education. The federal government cannot pass a law banning handguns, right? U.S. versus Lopez. So there's a lot of court cases that we look at that we say, okay, that one set the precedent that now all of the cases are based on. That is the biggest influence on the Supreme Court is precedent. Okay. Within the Supreme Court themselves, you have the Chief Justice. He always votes last. So let's say we're doing the whole rule of four, or they're going to do an opinion. He will always vote last and maybe shift it, being 5-4 or 4-5. So there's a little bit of power there. The Solicitor General is the top lawyer for the federal government. So essentially, they work for the federal government. They argue cases on behalf of the federal government, if you will. They're the government's top lawyer. And then you also have like the Attorney General. And then we can also look at outside of government. Remember this? Amicus curiae briefs, these are filed by interest groups as a way to try to put in a little bit of influence on the court to say, hey, there's a lot of people that are on the side of this issue. Don't rule against it. The opinions, I'm not going to get too much into these opinions. I think some of it can be a little bit overwhelming. The majority opinion is the only one that matters, right? So if it's 5-4, this is the one that has historic weight, historic precedent. The 4 is just dissenting opinion. It's called the minority opinion. You can write an opinion that agrees with the majority or agrees with the minority, be honest with you, but for a different reason if you want to. And that just allows you to be able to kind of have your ability to give your say as a justice. You can also do what's called a per curiam opinion. That's an anonymous opinion in which the court is basically so much in agreement with this. They just basically put out a ruling that says we're in favor of this. We're going to stop this. We're going to continue this. They did this one, I believe it was with Gregg versus Georgia. I'll have to go back and look. But the court case that ended the death penalty, I believe that was decided through a per curiam opinion. And then they ultimately had to rehear that one again, decide whether or not they wanted to bring back the death penalty. But hold me on that. But Gregg versus Georgia might be the one where they brought back the death penalty. It might be Furman versus Georgia where they ended the death penalty. Someone can look me up on that one. Let me know. Okay. So a couple things here. I'm going to skip over this because we're not worried too much about those issues right now. Okay. So the rule of 4 is really important. 4 justices have to vote to hear the case. If they vote to hear it, then they will hear it. Okay. And that's the most important part that we can kind of say that brings about the writ of cert. If 4 justices say, hey, I want to hear that case, they bring it on. Okay. The 4 parts of the Supreme Court case are, I said, BOCO. The briefs, these are kind of like the Cliff Note version. The judges get the oral arguments, or they get, the earlier kind of like the summary of the cases ahead of time. The oral arguments are actually the trial part. They only last 30 minutes. So it's actually a pretty quick process in which you have 30 minutes to basically hear the entire trial. Lawyers for each side present oral arguments. They're often questioned by the justices regarding their arguments, and they're usually pretty quickly. And so, this is where you actually are not going to have a chance to get up there and talk. The judges are just going to hound you with questions and bombard you trying to get their questions answered. It's almost kind of like going through like a thesis defense or something where you are being put on the spot to defend your position in front of the top legal minds in America. The conference takes place on Fridays. They don't hear cases. They have what's called Friday conference, and that's when they get behind closed doors and they vote to determine how their decision is going to be, and then they write their opinions. And opinions are just that, right? The majority opinion is the only one that matters. Okay. A couple things here. Judicial activism versus judicial restraint. Let me go here. So when we think of activism versus restraint, think of activism as the Supreme Court's ability to use its one superpower, judicial review. Right? You can have an activist judge that's very conservative or that's very liberal. Don't think of activism as liberal only and restraint as conservative only, right? They can actually go back and forth a little bit. So judicial activism is this idea that the Supreme Court's going to step up and basically make law or step up and override Congress if they feel like, they have the power to do so. This gets to a lot of other terms we can get into. Strict constructionists and loose constructionists, these are ways we kind of define like how judges interpret the Constitution. If they're a strict constructionist, they look at the Constitution like the Founding Fathers did. We don't really want to add a whole lot in there. We're not trying to have a lot of implied powers. We're not trying to add due process. and some other areas. A loose constructionist is going to say, let's have an interpretation that works for our modern era. Judicial restraint is just like the ability to say, I am not going to strike down laws. I am not going to get involved. If Congress wants to do this, they can do it, but don't tell us that we need to get this done. And we saw some of that with, some of the issues that were coming up from the Supreme Court recently, with the election, and even with like the Affordable Care Act, right? Where they're like, listen, you want us to get rid of it. You want us to do your job. That's your job. That's very much a judicial restraint kind of thing of like, we're not going to get involved in this. That's your job. Okay, activism is our ability to use judicial review and wanting to do that. Okay, arguments for and against activism. So don't think of activism as always being a good thing or bad thing. Sometimes it can be very, very good. We think of Brown versus Board of Education, Oswald versus Hodges. That was a very activist decision, and that Supreme Court gets involved into an issue where Congress didn't get involved and pass a law to integrate public schools to allow for gay marriage. But the Supreme Court did. And they stepped in a way that some people would say, whoa, should the court really be doing that? Right. But of course, if Congress is not going to act and it's an issue that we need a decision on, you can understand why activism happens in certain areas. You can also see, again, arguments against judicial activism. Do you really want 9 people, really 5 people making decisions for the entire country? What if the Supreme Court had ruled against gay marriage in Obergefell versus Hodges? What if they said it doesn't allow, right? I mean, what if they ruled against integration in Brown versus Board of Education? The only way you get around a Supreme Court decision is a constitutional amendment or another Supreme Court decision, which is why the idea of precedent is so important. The idea of we're going to use our previous experience and our previous decisions to kind of guide us. Okay. There's a couple of ways of measuring activism. You can take a look at how often they're going to overturn laws, judicial review, overturn precedent. The extent of the remedy is basically how they solve that. Think of Brown as a great example, or Obergefell. It wasn't just that gay marriage is now allowed in one state. I think it was Ohio. It's now saying that gay marriage is allowed in any state, right? Same thing with Brown versus Board of Education. Integration in public schools had to happen not just in Topeka, Kansas, but across the country. Okay. And again, that willingness to legislate from the bench. Okay, one more slide and then I'm done, I promise you. The process of selecting federal judges is pretty quick. It's not too bad. The factors are going to basically go into this. You really want to make sure you have experience and you want someone that has the credentials. For the Supreme Court, you definitely want someone that's a Court of Appeals justice. So it goes district court, Court of Appeals, Supreme Court, at least in the federal level. So you always pull from the Court of Appeals. We go back and we look at a lot of those justices. Almost every single one of them was a Court of Appeals justice before they were appointed to a Supreme Court. Okay, so qualifications are big. Senatorial courtesy, this is not required. But it's one of those things where it goes back to the tradition of letting the senators have kind of like be this deliberative body. So let's say there's an opening in Virginia. It would have been nice for Trump to go to Mark Warner and Tim Kaine, our senators here in Virginia, and been like, hey, do you approve of Judge Amy Coney Barrett? And of course, they probably would say no because, she's a Republican or she's more conservative, if you will. But the blue slip means I'm supposed to then take their recommendation and I can then take that to the Senate Judiciary Committee and I can say, you don't know who she is. Or you don't know who this person is, but the senators who are actually like in their home state where this judge will be serving approves of them. It's kind of like home state support, if you will. And I'm sorry, it's not for the Supreme Court. So it's for like a district court, a Court of Appeals judge, where you would actually try to say, listen, you're going to serve in Virginia in the Eastern, Western District, whatever. If Mark Warner and Tim Kaine support you, then you might be like, well, I don't know, who this judge is, but I do like Mark Warner and Tim Kaine, and if they approve her, then I'll support her. If that makes sense. Litmus test is trying to get like information to try to know if they're conservative or liberal. They want to ask questions about abortion, about healthcare, about all those things. And of course, judges know this. They know to be as neutral as possible and to not show, tip their hand, if you will, of how they're going to rule on decisions. And man, oh man, if you watched any of the confirmation hearing with Amy Coney Barrett, she said that time and time again. I'm not going to answer hypothetical questions. I am not going to answer that kind of stuff, where she was just basically saying, like, no justice has done that. So don't ask me to do that either. Okay. You do have a couple other things in here as well. You would try to, have political party, political ideology. Again, maybe to have more females on the Supreme Court, to have different races, different ethnicities, different religions. That can also go a long way to show diversification of the court, which might go better to help get your nominee confirmed. Just depends if the Senate's kind of challenged on that. Okay, guys, that was my video. Told you. Whew, went through a lot of information in video 42. Hopefully you got some of that down. I'm going to ask you some questions now in my document. Look forward to seeing you guys again real soon. Take care.